Hey guys, here we go. Rare occasion I have the house to myself. Um, I'm gonna just jump right into it here. If you do hear noise, that's the washing machine in the background. So instead of reading my original complaint, I'm gonna just re-upload it to my channel. I know that it was available at some point, and it's read by a robot. So the main reason for that is because it's very repetitive. Um, it just basically goes over everything that happened and just lays it all out, and just it's almost mind-numbingly repetitive in that it just states that Officer Laird um, recklessly, intentionally, with gross negligence and gross disregard for plaintiff's rights, arrested him, um, threatened to arrest him, detained him, threatened to blah blah blah, and it just goes on and on and on and on forever. 15 pages worth, 18 pages worth, and just lists each and every violation of my rights one by one. Um, but like I said, I will upload that again so you can listen to the original complaint. But it is in such great detail. It's just insane. It's agonizing how much detail it goes into about each specific act that was carried out, and how it violated the Constitution, how it went against. Um, sorry, I was getting a call. How it went against the Constitution and my rights. Okay, so here we go. This is their response. This is what initiated my response to their response to my response, blah, blah, blah. Here we go. Remember what I said about how detailed it was? Here's how they start off. May it please the court, now comes defendant, City of South Padre Island, David Laird and Claudino Carroll in their official capacities, therefore defendants, and file this motion pursuant to Rule 12.6b and the controlling precedent set forth below. So for those that don't know, a motion 12, a Rule 12, is pretty much what every single municipality or government defendant does to start off with. They're hoping that they can convince the judge, who is, of course, very busy with, lots of cases, to just slough it off, ignore it, dismiss it, based on it just being a waste of his time or being frivolous. Okay? So when I first saw this, I thought like, something horrible had happened where, uh, like there was some serious flaws in my case. I didn't realize what these guys really are, and how this is just something that all government defendants do. Probably more than that. I'm not an expert in any of this, by the way. I'm also not an attorney. I'm doing this pro se. Okay, that means I'm representing myself. Uh, but this is the knowledge that I've acquired through going through this procedure. A trial by fire is what I call it. So they filed this motion 12, this motion to dismiss. It's Rule 12 B6. It's just basically them claiming that I didn't prove my case. Plaintiff vaguely alleges that he was wrongfully detained and questioned, had his property briefly and lawfully seized, and was retaliated against for engaging in the free speech of filming police in violation of his First, Fourth, and 14th Amendments on October 14, 2020. See plaintiff's complaint. Plaintiff also alleges that various civil rights of his were violated by the South Padre Island Police Chief Carolyn O'Connor, South Padre Island Police Officer David Laird, and a John Doe SPI detective in their official capacities. Based on his pleadings, plaintiff fancies himself a YouTube First Amendment expert / auditor, self-cast in his role as a First Amendment civil rights protector and government watchdog. The plaintiff apparently travels around hoping to put himself and police officers into gray areas that will agitate and upset police officers into actions that he deems unconstitutional, presumably to be followed with self-drafted, legally insufficient lawsuit pleadings. Woo! Plaintiff's complaint does not properly state a cause of action against the defendants. Defendants hereby request that the court dismiss plaintiff's complaint and the causes of action against it pursuant to FRCP 12b6. A motion to dismiss for failure to state a claim upon which relief can be granted tests the formal sufficiency of the statement of claim for relief in plaintiff's complaint. And then he lists a bunch of court precedences. Doe Hillsborough ISD 81 F3D, 1395, 1401, 5th Circuit, 1996. A motion to dismiss under FRCP 12b6 is not appropriate unless the plaintiff's pleadings on their face show beyond doubt that the plaintiff cannot prove any set of facts that would entitle him to relief. A bunch more court precedences. Conclusory allegations or legal conclusions masquerading as factual conclusions will not suffice to prevent a motion to dismiss. Rule 12b6 allows dismissal if a plaintiff fails to state a claim upon which relief can be granted. That's all I did over and over again, about 1,000,000,000 times. Pursuant to Rule 12, plaintiff's claim survives only to the extent that it passes the plausible pleading test of Ashcroft versus Iqbal. To survive a motion to dismiss, a complaint must contain sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. Like a video of me getting arrested after asking the officer, "Can I have your name and badge number?" Yeah, that sounds factual and sufficient to me. Apparently that's not enough for them. This does not require detailed factual allegations, but it does require more than labels and conclusions or a formulaic recitation of the elements of a cause of action. In other words, you can't just say, "This felt like a civil rights violation, therefore I file a lawsuit and therefore I win," which makes sense. I agree with that. But the problem is they're trying to make my extremely detailed lawsuit with video of everything that happened that shocks the conscience as soon as you watch it. They're trying to equate that with this formulaic recitation of the elements of a cause of action. Threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. In plaintiff's complaint, a number of conclusory assertions are made regarding plaintiff and defendants. Both the factual and alleged legal assertions in the complaint are insufficient for purposes of pleading requirements in a number of ways, as more fully pointed out below. Plaintiff fails to state a Section 1983 claim for which relief can be granted. All claims fail. Monell claims, generally plaintiff's pleading. Plaintiff brings a variety of claims pursuant to 1983 to address the Monell hurdles, with such claims in incredibly generic and conclusory fashion, merely asserting throughout, and now this is an actual section from the complaint, the acts complained of were carried out by the individual defendant in his capacity as a police officer, pursuant to the customs, usages, practices, procedures, and the rules of the city of South Padre Island. Defendant, while acting under the color of state law, engaged in conduct that constituted a custom, usage, practice, procedure, or rule of the respective municipality authority, which is established constitutionally protected right constitutionally protected right to be free from punishment and deprivation of life, liberty, and property without due process of law under the Fourth Amendment. The acts complained of were carried out by the defendant Laird in his capacity as a police officer, pursuant to the customs, usages, practices, procedures, and the rules of the city of South Padre Island. At all times relevant to this complaint, defendant O'Carroll and city of South Padre Island acted with deliberate indifference to plaintiff's constitutional rights by maintaining policies, practices, and customs that condoned and fostered defendant Laird's conduct. City of South Padre Island maintained a custom or policy that permitted officers to prevent individuals from recording public officials. This policy allows officers to detain and search individuals and seize their property for recording police officers. This custom and policy that prohibits recording police property, vehicles, and police officers was the standard operating procedure for defendant Laird, including supervising police officers. At all times relevant to this complaint, defendant O'Carroll and city of South Padre Island acted with deliberate indifference to plaintiff's constitutional rights by maintaining policies, practices, and customs. You get the idea. Ad nauseum. Okay, beyond this, plaintiff pleads nothing against defendants in support of Section 1983 constitutional claims. Plaintiff pleads absolutely no facts in support of an actual pattern, practice, or custom of unlawful detainment, questioning, unlawful seizure of property, First Amendment retaliation, failure to train and supervise, so they're saying that I needed to show, okay, back on January the 14th, 2003, Officer Laird requested permission to go outside and beat the living shit out of a reporter, at which time Supervisor Sergeant John Doe, badge number 1483, stated, "Yes, go beat the hell out of that reporter. We hate reporters out here." Okay, Incident 1. Incident 2, November 14th, 2007. Officer Laird requested permission from Chief of Police O'Carroll to go and beat the ever-loving crap out of a black man who was holding a camera outside the police station. Chief Claudine O'Carroll then stated, and here's the recording of her saying it, "Yeah, beat the hell out of that black man. We hate black people around here." That's what they think, that's what they're claiming I have to come up with in order to prove that my civil rights were violated and that there was a pattern. Okay? Not just the fact that police officers are trained to be professional, they're trained on First Amendment, and everything that they do is to avoid negative scrutiny, negative press, and escalating situations, okay, for no reason whatsoever. Okay, that right there, just the fact that he arrested me for having a camera, telling them to go back to work, and then asking for his name and badge number, proves that they had a bad policy in place. But these guys are saying, no, I'm supposed to show just specific date and time where they literally just had this long pattern for years and years and years and years, and it just was passed down from officer to officer. And when one chief of police would die of old age, he would pass on all the customs of racism and racial profiling and First Amendment violations, and I have to have all that documented, otherwise there's no case. Come on, give me a break. A municipality is a person subject to suit under Section 1983. To state a claim for municipal liability, Section 1983, a plaintiff must establish three elements: a policymaker, an official policy, and a violation of constitutional rights whose moving force is the policy or custom. Petrovsky versus City of Houston, citing Monell at 694. The elements of the Monell test exist to prevent a collapse of the municipal liability inquiry into a respondent superior analysis. Zarno versus City of Wichita Falls. A municipality may not be subject to liability merely for employing a tortfeasor. ID, to state a claim for a city's liability under 1983, a plaintiff must allege facts that can establish proof of 1, a policymaker, 2, an official policy, 3, a violation of the plaintiff's constitutional rights, where the moving force behind the violation is the city's policy or custom. How about every single supervisor walking away, refusing to identify themselves, refusing to address what happened, and not one of them saying, hey man, you blew it, sir, we're sorry that happened, that's a violation of our policy. No, they acted like everything was fine, and they were going to give their name and badge numbers. So this goes on, you guys. That took us to whopping page 4. This video is already 12 minutes long, so now I'm starting to second guess whether or not I should read through all of this. I'm going to go through some of the bullet points here. No policy or policy statement pled. There's a whole section on that. No pattern, practice, or custom pled. There's a whole section on that. Failure to train and supervise claims not properly pled. Plaintiff also pleads in conclusory faction that there was a failure to train and supervise at the SPIPD. As to plaintiff's failure to train and failure to supervise claims, these too are woefully deficient to withstand basic pleading scrutiny. In his complaint, plaintiff does not cite to an official policy of the city of a failure to train. Therefore, he necessarily must be alleging a custom or practice. However, plaintiffs failed to plead factual allegations sufficient to show that such a policy, practice, or custom exists. The standard applicable to a failure to train claim is the same as the standard for municipal liability. Roberts versus City of Shreveport. So they're saying that just the fact that this guy was employed by the police department isn't enough for them to have liability for anything that he does. So he can go out and just start murdering and killing people. They're not responsible. This is the stuff that cities and city governments write into law or into their policies to exempt themselves from responsibility, oversight, and transparency. So pretty much they repeat themselves here. They just go down the list. Here's the Fourth Amendment claim. Fourth Amendment claim fails for failure to state a claim for which relief can be granted. Plaintiff pleads probable cause. Plaintiff pleads his Fourth Amendment right to be free from wrongful detention and questioning and lawful seizure of property were violated. Plaintiff's Fourth Amendment claim fails for failure to bring a claim pursuant to Section 1983 as discussed above, but also fails for a failure to plead any basis for a Fourth Amendment claim, as plaintiff does not allege the necessary facts to support a Fourth Amendment claim. You want to substantiate that somehow? The video literally shows me being arrested for nothing, absolutely nothing. If that's not a Fourth Amendment violation, I don't know what is. Plaintiff alleges that PD officers' detention of him and request for his ID violated his Fourth Amendment right to be free from detention absent reasonable suspicion. No, I don't actually claim that. The U.S. Constitution does. The police can stop and briefly detain a person for investigative purposes if the officer has a reasonable suspicion supported by articulable facts that criminal activity may be afoot. And so somehow or another, they believe that recording police from a public space with no signs restricting either the recording or the presence of the photographer constitutes reasonable suspicion. Okay, how? I don't know. Under the two-part Terry reasonable suspicion inquiry, a court asks whether the officer's action was 1, justified at its inception, and 2, reasonably related in scope to the circumstance which justified the interference in the first place. The Supreme Court has stated that in making a reasonable suspicion inquiry, a court must look at the totality of the circumstances of each case to see whether the detaining officer has a particularized and objective basis for suspecting legal wrongdoing. The Supreme Court has stated previously that reasonable suspicion exists when the officer can point to specific and articulable facts, which, taken together with rational inferences from those facts, reasonably warrant the search and seizure. What part of, no, I don't need help, you can go back to work, and can I have your name and badge number, satisfies what you guys just heard the Supreme Court saying is necessary for reasonable suspicion? Nothing, not a thing. Plaintiff's First Amendment claim fails for failure to state a claim for which relief can be granted. Despite using 3 counts, it was actually 8 counts. So it shows how close to attention these guys are paying, how much attention to detail they're paying. Despite using 3 counts and 5 pages, it was 8 counts and 15 pages, and 5 pages to redundantly plead his First Amendment claims. Plaintiff's complaint does not adequately allege a First Amendment claim for which relief can be granted. Plaintiff's First Amendment claim fails for failure to bring a claim pursuant to Section 93, as discussed above, but also fails for a failure to plead any substantive basis for a First Amendment claim. Plaintiff asserts that his First Amendment rights were violated when the city police officers unlawfully prevented him from recording the officers, vaguely alluding to the fact that the recording itself was a protected First Amendment speech or activity. So they're disputing that, when it's already been well established, and that the officers retaliated against him for, and presumably that this retaliatory conduct was briefly taking his phone and knocking it to the ground and detaining him briefly to question him. Why? Why do you need to question a photographer? It's not necessary. What crime can they point to that I was in the process of committing or about to commit or had already committed that justified that detainment, that arrest? It was an arrest. Because they questioned that later on too, that I never said anything about an arrest when I did. The Fifth Circuit has held that to establish a First Amendment retaliation claim against an ordinary citizen, a plaintiff must show that 1, he was engaged in constitutionally protected activity, 2, the defendant's actions caused plaintiff to suffer an injury that would chill a person of ordinary firmness from continuing to engage in that activity. Oh, I was most definitely chilled. Having your phone thrown on the ground, being spun around and handcuffed, that most definitely chills your First Amendment. The defendant's adverse actions were substantially motivated against the plaintiff's exercise of the constitutionally protected conduct. Defendants questioned the fundamental legal basis of plaintiff's proposed First Amendment rights. God, that just sounds horrible. The United States Supreme Court has not directly held a constitutional right to record police or law enforcement activity in public exists. The Fifth Circuit, in an opinion for which there was a dissent, has held that First Amendment principles controlling authority and persuasive precedent demonstrate that a First Amendment right to record the police does exist, subject only to reasonable time, place, and manner restrictions. That's actually not true. It does not say that you're free to exercise your First Amendment subject to time, place, and manner restrictions. No. That's a misrepresentation. Governments have the authority to impose time, place, and manner restrictions under certain circumstances, but it has to be content neutral. It can't just be against First Amendment auditors. If they're going to prevent one group from exercising their First Amendment rights, they have to prevent all groups. It can't just be based on the content. The fuck the police people cannot be prohibited from having their First Amendment rights on police property or public property, which is what it is, that we leave in the care of the police. But then the people who are the bootlickers and want to wave their blue line flags, they're allowed because the police agree with their message. Okay? That's up to government to decide if time, place, and manner restrictions apply. Tries to make it seem like every single person who wants to exercise their First Amendment must check first with the police or with their government to see if it fits into time, place, and manner restrictions. And the reason why I know that is because he literally says so in one of his responses. So this is the intimidation part at the end. They basically say that they want this to be dismissed, and they also want me to have to pay the city's legal fees and any other relief, okay, that can be granted and given back to them for the horrible, horrible actions that I'm putting them through. Okay, so that's like basically saying, hey, buddy, you just got through suing the police department. Not only are we going to reject everything that you said, call it into question, say that you failed to make even a partial case, but then we're going to say, and now they didn't counter sue me, okay, but they are putting in there that not only do we want it dismissed and him get nothing that he's asking, but we also want the court to grant us all of our legal fees back that I have to pay for them. Okay, so that's what happens, guys, when you sue a city police department. Okay, it's not a walk in the park. It's not a piece of cake. You're in for a battle royal. And so I responded to this with basically a manifesto about living in America and how we are free to do what we want to do as long as it doesn't break the law. And we don't have to ask police for permission. And I give all the examples of the TSA at airports, of federal buildings, and another place that I can't think of right now. Oh, police departments, where they literally are issuing and have issued guidance to all their officers saying, don't mess with First Amendment auditors. Leave them alone. It's not legal for you to arrest them, harass them, intimidate them, question them, detain them, just because they're recording alone. That's not enough. This department did not have that procedure or policy in place. And they still tried to argue with that. So I'll read my response to this later, unless you guys want to hear more of this. I think I kind of gave you the basic gist of what they say in here. They just go down the line and they just repetitively state over and over again that I failed, I didn't prove it, I can't prove it, it's not provable, blah, blah, blah. And then my response is the juicy one. That's the one I think is juicy. And then I can read you their response to that, and then my final response, which is the one that's hanging right now as we wait for April 15th, which is our pretrial conference. Okay.